This is a case that may give you a haunting experience. It's a story that forces us to ask uncomfortable questions about our judicial system, about justice for the victim, and the rights of the accused. It's a story about a brutal crime, a death sentence, and a shocking twist in the Supreme Court that left everyone questioning what exactly is justice. At the heart of this case is a devastating tragedy. A 12-year child was raped and murdered in a brutal manner. The investigation seemed solid. A dog squad traced the child's belongings. Other belongings were found by the police in the field of two accused men. The evidence seemed to point squarely at them. They were arrested, the trial began, and the trial court delivered the stern verdict: death penalty for one and life imprisonment for the other. The accused appealed to the High Court, but the High Court confirmed the punishments. It seemed like the case was closed. But then they appealed one last time to the Supreme Court of India. And here, the entire case turned on its head. The Supreme Court did not just reduce the sentence, it acquitted both accused of all charges and ordered their immediate release. How could this happen? How could two courts, including a high court, get it so wrong that the Supreme Court would throw out of the entire case? The answer lies not in the crime itself, but in how the investigation and trial were conducted. The Supreme Court's analysis revealed shocking procedural lapses that, in its view, made the entire case against the accused untenable. Let's break down exactly why the Supreme Court took this monumental decision. First, the phantom DNA report and the sacred right of the accused. The section 313 CRPC. The first major flaw was with the DNA evidence. The initial DNA report filed in the trial court was inconclusive. But then, during the appeal in the High Court, a new DNA report was filed, and this one matched the accused. The Supreme Court had a huge problem with this. This is where Section 313 of the CRPC or 315(1) of the BNSS becomes the hero of our story or the villain depending on your perspective. This section is a fundamental right of the accused. It's a mandatory procedure. Any new evidence presented against the accused must be put to them directly and they must be given a chance to explain it. This is not a mere formality, it is the cornerstone of the fair trial. The prosecution cannot just spring new evidence without giving the accused a chance to respond. In this case, the new damning DNA report was never put to the accused under Section 313. It was as if it didn't exist in the eyes of the law. Therefore, the Supreme Court had to neglect it. They could not consider it. Why is this change required? The psychology behind it. This rule is built on a profound psychological and legal principle: the right to a fair defense. Imagine being accused of a crime and the prosecution brings up a crucial piece of evidence you have never seen before at the last minute. You had have no chance to challenge it, to question its authenticity, or to prepare a counter argument. This prevents trial by ambush and upholds the principle that it's better for 10 guilty persons to escape than for one innocent person to suffer. The system is designed to be robust, even if it seems to create loopholes. The second part, the missing expert witness. Secondly, the Supreme Court pointed out another critical flaw. A scientific report like a DNA analysis is not just a piece of paper. It requires an expert witness, the person who conducted the test, to stand in court, take an oath, and explain their findings. They must be cross examined by the defense lawyer. This cross examination is vital. Was the sample contaminated? Was the methodology sound? The defense has the right to poke holes in the evidence. In this case, there was no examination of an expert for the DNA report. The report was just filed. Without the expert, the report is just as an opinion without a face or a foundation. The Supreme Court rightly refused to consider it. Number three, the evolving complaint, a story that grew. Third, the court looked closely at the initial complaint. The first complaint is the foundation of any case. Any major trials added later or reviewed with suspicion unless backed by solid evidence. Here, the initial complaint made no mention of the child's interview. This crucial detail was added in a subsequent statement. The Supreme Court observed that this made the complaint seem exaggerated afterwards. It raises a red flag. Was the story being built and strengthened after the fact? This does not mean the crime did not happen, but from a legal evidence standpoint, it weakens the prosecution's credibility. The fourth problem, the dog squad and the specter of planted evidence. The evidence from the dog squad was also poorly documented by the investigating officer. The Supreme Court did not just see this as a minor error. They raised a terrifying possibility that the evidence may have been planted. When procedures are not followed, when the chain of custody is broken, it opens the door to doubt. And in a criminal case, especially one carrying a death penalty, the benefit of that doubt must go to the accused. The fifth point, the misapplication of a powerful law. Section 106 Indian Evidence Act. Now, this is the crucial legal battle within the case. The lower courts heavily relied on the Section 106 of the Indian Evidence Act, now 109 Bharatiya Sakshya Adhiniyam. Normally, the burden of proof is always on the prosecution side, innocent until proven guilty. But Section 106 is an exception. It says that if a fact is especially within the knowledge of the person, the burden to explain it shifts to them. A classic example, if a dead body is found in your living room, you are the one who knows how it got there. The burden shifts to you to provide an explanation. The lower courts used this against the accused since the child's belongings were found in their field and they could not prove their innocence, they were deemed guilty. But the Supreme Court slammed this reasoning. They clarified that Section 106 cannot be used to fix a fundamentally broken case. The court stated that when the entire investigation is flawed and the possibility of evidence being planted exists, you cannot use this section to force the accused to prove their innocence. The initial burden of proving a solid, trustworthy case still rests entirely on the prosecution. The lower courts had put the cart before the horse, the double edged sword of justice. So, after all this, the Supreme Court dropped all charges murder, rape, and causing the disappearance of evidence against both accused. This case is a sharp, double edged sword. On one edge, we have the unimaginable tragedy of a 12-year-old child who suffered a brutal fate. If the accused were truly guilty, then the Supreme Court's decision, based on procedural technicalities, has allowed monstrous criminal to walk free. Has our system helped the accused and failed the victim? On the other edge, we have the principle of liberty and the horror of wrongful conviction. Two men were incarcerated for years, blamed for a heinous crime, with one sentenced to death. If they were innocent, as the Supreme Court's ruling suggests, then the real culprits are still out there. The victim's family has not seen true justice, and two innocent men had their lives destroyed by a sordid investigation. The real failure, as the Supreme Court highlighted, was not in the final judgment, but at the very beginning with an investigating agency that either by incompetence or malice failed to do its job correctly. This case is not just about one child or two accused. It's about the integrity of our entire judicial system. Do we value correct procedure over a desired outcome? And in the end, which one truly delivers justice? What are your thoughts? Was the Supreme Court right to prioritize procedure, or did it fail the victim? Let's have a respectful discussion in the comments below.